Dave said I should go first. I'm Jim Archer. I'm actually one of the authors of 7390, one of the two authors. I wrote the portions pertinent to 114711, the portion defining suitable person, and the portion modifying the fee section of that particular statute. I'm also an NRA-certified pistol, rifle, and shotgun instructor. The first person, to my knowledge, to sue my police chief in order to have him accept an application for a concealed handgun permit. Person who briefed the Mazda case back in 2004. And for it's worth, a father. I guess, the mother's role model, so I get to be a father too. I'd like to briefly address 739, but first, even more briefly, the school gun bill. So as an NRA-certified instructor, I know that handguns, when carried, are most safely carried in a holster and left in the holster, a good holster that covers the trigger. If we have a bill or a law that says you can't bring your handgun into a particular location, what's going to happen is people are going to drive. If they're not allowed in the parking lot, they'll park somewhere else. Then they'll have to remove that handgun from their holster and put it in the console, in the glove box, wherever they're going to put it. Perhaps they'll clear it, perhaps they won't. Perhaps someone will see them doing that. They'll go into the school, they'll pick up their child, whatever it is their business is there, they'll come back out, and they'll reach for the handgun, and they'll try to put it back in the holster. This is the most risky time to be handling a handgun, when you're holstering it and unholstering it and clearing it and unclearing it and all that stuff. So by not passing this legislation, I would submit that we're actually being safer because we're avoiding all those potential accidents. So that's all I have to say about that as an NRA-certified instructor. People have addressed the wisdom of the carry, not carry separately. I'll leave that to them. Regarding 7390, everything in that bill is a direct response to actions or inactions by various licensing authorities, most of whom are police chiefs in the state of Rhode Island, except for the town of Exeter, where it's the town clerk in combination with the town sergeant. I appreciate the chairman's comments that the committee is aware that there are discontinuities or irregularities as they vary from town to town, and also his comments to the former chief of East Providence concerning that we currently have the law. It's just a matter of how the licensing authorities are executing the law. I think actually former Chief Tavares was a great example of why this bill is important, because he seemed to acknowledge that the law exists, but then explained that he was doing applicants a favor by slow walking or denying their applications. In fact, he's one of the chiefs we've had the most difficulty with during the past 14 years. Since I sued Chief McGarry in Smithfield, and to his credit, he got right on board when the judge told him and did the right thing. And since the Mazda decision, which declared that there's a statutory entitlement to a handgun a handgun carrying permit for those persons who meet the requirements in statute, he was among the most difficult chiefs to get on and follow the law. And in fact, until the Gadomski decision just last year, we never did get these problems to comply, and still these problems having difficulty complying with the mandates of the statute. As I said, everything in the bill is a direct response. The primary purpose of the bill is to provide that there's a timely review, because many chiefs sit on it. We've had people talk about 1 year, 2 year, more than 2 years waiting for a response. Without a response, you can't move forward with an appeal. The appeal in Rhode Island, per the Mosby decision, is directly by cert to the Rhode Island Supreme Court. It's a discretionary writ, of course, and they have turned down a number of these. And, of course, they don't say why when they turn down something, but I would suppose that it's because it's not a new question for the court. What people need is a method of appeal that is reliable so that they get their day in court, quite frankly. And so we provide for that with the Administrative Procedures Act, which I think is, rather than constructing entire new appeals route, I think it's reasonable to exercise what we already have in statute, where there's a body of case law and attorneys are familiar with it. That's generally what I wanted to do was point out that things are all a response, everything in there. The primary purpose of the bill being to provide appeal and for a timely review, and for that the licensing authority provides the rationale for the denial as mandated by the Rhode Island Supreme Court in the Mosby decision. One last thing, there's been a lot of discussion about whether or not CCW holders are trained to engage armed criminals. CCW holders should be running away unless they have no choice whatsoever. They are there to defend themselves or their family in the event of grievous bodily harm from which they cannot escape. We're not expecting CCW holders to rush forward into a crime scene. That's the job of police officers. Now, if a CCW holder happens to be trapped in a school, one would expect that perhaps he or she would attempt to defend themselves and the people around them. But the better approach, and we say this when we train people, is always to simply run away. Run away. Generally, unless you're about to lose your life or someone else about to lose their life, it's not worth taking a life, and it's not worth the aggravation that comes after. If anyone has any, there is one important thing. There's one minor drafting error that didn't quite make it in the translation. On the third page of the bill, 9.8, the amendment was, instead of proper lawful reason, there should have been any or a lawful reason there. Apparently that just got lost in the translation somewhere when the bill was entered into the system. So that's it. You folks are saints. I really appreciate all your attention. Every one of you, whether you support these bills or not on either side, I do appreciate the time and attention that you've put into your duty here this evening. We all appreciate it. And I apologize for the lectures and no vocabulary lessons, I promise. Thank you very much.
Yes. Representative O'Grady.
Sir.
And I apologize for throwing a question at you at 10 minutes of midnight, but
it's okay.
I was curious I believe it was the case, I didn't catch the citation, but the one that resulted when you sued your police chief?
That was Archer v. McGarry.
Okay.
I was the plaintiff.
So at some point in your testimony, you said that the decision, I don't know if it was that one or another one, found that there was a statutory right to have a concealed carry.
No, I apologize. I was probably speaking a bit quickly. That particular case, I saw a writ of mandamus compelling the police chief to simply accept and consider the application because at the time, like almost every single police chief in the state, like every single licensing authority in the state, they would simply say, go see the Attorney General, don't talk to me. Now, of course, the law says that the licensing authority for 1147.11 shall issue, whereas 1147.18 for the Attorney General says may issue. So certainly an applicant would prefer to visit his local licensing authority, which has a more stringent mandate.
I get that, but did you not say that
in the Mosby case 2 years later, a non-resident named Mosby, an electrical engineer from the state of Massachusetts, sued the Attorney General, sued in Superior Court seeking Administrative Procedures Act review of his denial from the Attorney General. And in that case, the Supreme Court of Rhode Island upheld the Attorney General's may issue authority because the court said that Mosby, because there's no indication that he was unsuitable, had a statutory entitlement to the permit from any of the licensing authorities of any of the cities or towns.
Okay, so my question is this. We've heard a lot of folks tonight talk about Article 1, Section 22 of the Constitution.
Yes.
So I'm curious why the court would not have found a constitutional right as opposed to a statutory right in that case.
So the Mosby decision is a fascinating decision. It's been reviewed ad nauseum by various legal scholars, and with the court reviewed at length. Half that decision was discussing the historical basis of Article 1, Section 22. What the court actually held was that ultimately they don't need to reach that question because the statute answers the question. There's a statutory entitlement. But what the court did say, and I'll be very upfront about the Constitution, there's the key element of Article 1, Section 22, per our Supreme Court. It was Justice Williams who wrote this decision, with Justice Flanders being the only dissenting justice at the time, was that keeping was the sin no quo, the essential element of the right. And he said that because of the word bear, that they keep him bear, he felt that bear introduced a military nexus into the right. And he said that the people of Rhode Island have some right to bear arms, but they don't evaluate the limits of that right at this time because of the statute. They're going to rely on the statutory framework to answer the question, which really calls into question the entire review of the Constitution. Since then, however, the United States Supreme Court has clearly defined the word bear as it relates to the right to keep and bear arms. And Justice Scalia was very clear that bear means exactly the conventional meaning that we all think of bears is to carry. Does that answer your questions? Thank you very much.